oil and gas going on. There is an expectation that the South China Sea carries with it in its subsoil a lot of oil and gas. So you see why the South China Sea is very important. Now, why is there a controversy about the South China Sea? Can we have the second slide? There is a controversy because you will note in the slide it says 3 groups of insular features. Especially for the freshmen, take note of the words insular features. Insular means within the sea, and features is a purposive use of a term. We don't use islands yet, but we say features. Features means something within the sea, within the South China Sea. Later on, we will explain to you what type of features are there. But for the moment, let us call them features. Well, why is there a problem? Because within the more than 3 million square miles, there are groups of features of interest to many countries. So you will see in the slide the paracels that's nearer to Vietnam, that is not our concern, but that's an active area of dispute. Scarborough Shoal to the north, or what we call the northern sector, that is where Panatag Shoal is, our Panatag Shoal. To the south, you have the Spratly Islands, or sometimes known as the Spratly groups. Now, just in terms of number of features in this, you can see tiny specks. The Spratlys, there are about 750, widely spread reefs, reefs, R-E-E-F-S, reefs within the Spratlys. Now, approximately 40 are above water some of the time. But roughly 20 or half of it are above water all of the time. Then, what have the 6 countries surrounding the South China Sea done? Even before the turn of the century, but by the turn of the century on an escalated scale, many countries started occupying either reefs, some of the features, or some of the small islands, or some of the bigger small islands in the South China Sea. So, you have many countries, the Philippines has around 7, Vietnam has, China has. They started occupying these features. Now, for the moment, I will just mention to you 2 important features, and Florine will go back to this later on in this talk. You're familiar with Kalayaan, our Kalayaan, that is occupied by the Philippines, I think less than 0.3 square kilometers, square mile, 0.4. We have a municipality there. The other one that you should pay attention to is Itoaba, occupied by Taiwan. It's around 0.43 square kilometers. So our Kalayaan is smaller. So these are among the features being occupied by different countries. So the chief protagonists are around six countries. Now, against that backdrop, you have a semi-enclosed sea. You have many features, and you have many countries making or claiming that they have occupied. When did the problem escalate? The problem escalated in 2009 when China started making a claim to its so-called 9-9. We have the next slide. in a formal notification in 2009 to the United Nations, China appended or attached a map of the South China Sea with 9 dashed lines. You see it in the slide. That is why it's called the 9 dashed line. So, naintindihan niyo namin. It's called the 9 dashed line. If you will notice, it covers more than 60% of the South China Sea. If you notice, that's almost next to Palawan. I think that's almost 25 miles. One of the dashes is just 25 miles of Palawan. Now, China said, and later on we will come back, and Florin will explain to you more, claiming its so-called indisputable sovereignty over all of the islands and sovereign rights over all of the resources and the waters. For now, you just remember, later on it will ring a bell. The key words are sovereignty and sovereign rights. In 2009, and between 2009 and 2010, the Philippines, together with many other countries, vigorously opposed this claim by China. How did we oppose it? By filing what are called note verbal. A note verbal is a formal notification by a country to another country that we were objecting to the claim. So that is the birth of the 9-dash line. And in a sense, China's claim to the 9-dash line escalated the tensions within the South China Sea. And if we have the next slide, please. Now, we are superimposing here the 9-dash line with the 3 groups. So you will see that they are now claiming sovereignty over all of the 3 groups where most of the countries have made their own claims. Okay, so far, so good, no? I also miss teaching because, like Florin, we also taught Constitution 1 and 2 in UP. So, I was never a terror professor, so I didn't to do this. I always say, oh, okay ba? So far, so good. No? And from your looks, wala man namang physical looks. No? Ibig sabihin, medyo naiintindihan niyo pa. No? Now, can we have the next slide, please? Now, what prompted the Philippines to bring arbitration? Okay. You remember the 9-dash line was 2009. So, even before 2009, there was already friction. There was already a dispute between the Philippines and China. And I'll just take one example. 1995, way before 2009, China occupied what you know now as Mischief Reef. It's a reef. Permanently underwater is a reef. They built something there. Initially, they just built bamboo stilts, saying this was going to be used as shelter by Chinese fishermen during storms. We protested against it. 2009, over the years, exchange of note verbals, exchange of communications, and later on there were some conferences. So that was pre-2009. Now, remember again the timeline. 2009, 9-dash line. Beginning 2009, China escalated the tension with the Philippines. The Reed Bank, or the Recto Bank, this is where the Philippines is doing active oil and gas exploration. In 2010, in a series of actions, China was contesting the ability of our vessels to do studies. They protested award of petroleum black contracts. And so we were disputing this. It was escalating. So that was about the Reed Bank. Scarborough Shoal, towards April, I think. April of 2012. that's right, 2012, you have the famous Scarborough standoff. For the first time, China prevented Filipino fishermen from entering or fishing near Scarborough Shoal. This created a lot of tension. The President Benigno Aquino III, in two of his first two State of the Nation addresses, already hinted that given these escalations, the Philippines may have no recourse but to seek redress in international law. So, 17 years of failed exchange of views. Remember, 1995, we still brief. We already had the beginning of the spot with China. So again, exchange of note verbals. Just to give you an idea on the exchange, when we had to file and we were building up our evidence, I had to carry with me to Washington, D.C., 2 big oversized luggage, maletas, full of note verbals, minutes of meetings, showing that for 17 years we had engaged China in an attempt to settle the disputes. So, further recollection of my predecessor, Solgen Anselmo Cadiz, October 2011, he had a meeting with the President, Foreign Affairs Secretary, and he was instructed to start studying options on bringing a case, bringing the matter to international law. I came in as Solgen February 2012. Almost immediately, remember this the timeline again. I came in 2012, February. By April, we had a Scarborough standoff. Almost immediately, therefore, I was also instructed through the Executive Secretary to start studying, together with the Secretary of Foreign Affairs, the advisability of bringing relief in international law. Can we have the next slide, please? Now, and this is where I started my participation. I was Solicitor General, and the Solicitor General is the chief trial lawyer. He's the chief lawyer for litigation of the government, as distinguished from the Secretary of Justice. The Secretary of Justice gives opinions, is in charge of National Prosecution Service. Cases are handled by the Office of the Solicitor General. It is an independent agency attached to the Secretary, attached to the DOJ, but it is an independent agency. We don't report to the Secretary of Justice. So my role started to be as agent of the Republic for the possible case that we were going to file. Now, just very briefly, and Florin will go back to this. What is the role of the agent? First, he will have his own slides. The agent signs anything and everything that the Republic files if there is a case. Which means if you file a case, the Solgen will have to manage the litigation. That is why the term, you have to do your job as a litigation manager. Meaning you have to manage all the stakeholders, as you call them, doing all the inputs for the case. And then, very important, and this is purely mine, you need to be an honest broker. Later on, hopefully, when you finish first year, second year, third year, fourth year, and you pass the bar and you practice, you may be put into a situation where you put your legal skills, whether in a company or in government. When you get that high, there will be many different views about how to do things, as you know now, beginning to understand, especially in the field of law. So, when policy mixes with law, you have to be an honest broker. Hindi mo pwedeng sabihin na one party proposed a memo like this, and then you tell your boss, the president, ito po yung tama. Your obligation is to bring to the president all views, and if he asks you for your opinion, that's the time you can give your opinion. So, in a nutshell, that's the role of the agent. It's a difficult task, but it's a very challenging task, and that's one of the blessings that I had as a soldier. So, what were the specific jobs that we did? We had to select a pre-litigation consultative group. We had the late Justice Feliciano of the Supreme Court. We had Professor Michael Riesman of Yale and Professor Bernie Oxman of Miami University College of Law. They were part of the consultative group. Now, there was also a Philippine legal team, multi-department. The Office of the President, under Secretary Ochoa. The lead member was Mike Musni, who is one of your alumnus from the Office of the President. The DOJ was led by Dicky Paras, also of Ateneo. The Solgen, of course, I led it, and Sara Fernandez from the Ateneo, plus some of my staff. The Department of Foreign Affairs, Gilbert Suke, deputy, and we had some representation from the Department of Energy. Now, selection of international counsel. Why did we have to get international counsel? The answer is very simple. We had no experience on a litigation of this magnitude and scale. So you don't risk doing native talent or homegrown talent to do this. And later on, Florin will tell you also his anecdotes about that. So, how did we choose international counsel? I did what I was doing in the private sector. I conducted what we call in the private sector a beauty contest. It's like a beauty contest. So, but instead of parading, they have to submit a written memorandum strategy. They had to parade their skills because we have to go to Washington, D.C. many times to listen to them. And they had to submit written, and we had to listen to them. And also at the last, especially, they had to submit a financial bid. So, given all of this, we had to choose counsel. And in fact, one of my favorite anecdotes was the firm of Reichler, which we ultimately chose. When they made a pitch in Washington, D.C., we were there on another matter. They offered to bring us to dinner, and I said, no, you join us for coffee, and we will pay for the coffee. So they went to our small hotel, and that's where we got to know them. Later on, we of course chose them. If you ask why, because they were superior in my view and in the view of the whole Philippine team. We had to take a kind of a vote, and they were the unanimous choice. Now, part of the work is, of course, the most important is formulating the theory. By the time we had Reichler on board, and he had picked his own team, including barristers from London, we had to formulate the theory. This is one of the most important things in litigation. You have to know what are the facts and based on what is the law that you will apply. And then, of course, the evidence build up, meaning to have Philippine Navy get all the pictures and to have our evidence. And as you will know later, the submission we had more than 4,000 pages of supporting documents just at the first phase. So we now go to the next slide, which is so given the facts, given the situation, given the facts on the ground in the South China Sea, our interests, what was a feasible way to assert our claim? Ito yung sinasabi ko. So, what is our theory? Well, our theory is that what law governs is the United Nations Convention on the Law of the Sea, or UNCLOS. You see principal features of the UNCLOS. Now, what is the UNCLOS? Number one, it is a treaty. So it is written, it is a treaty. As Ambassador Tommy To of Singapore has so aptly called it, what is the UNCLOS? The UNCLOS is a constitution for the oceans. As in consti, it's a constitution for the oceans, just like the Philippine Constitution is a constitution for the Philippines. And therefore, if it is a written constitution, what does it stand for? Written rules, the rule of law, as Professor Miki said. So there is a rule of law governing the oceans. And the oceans, remember, are very important. You need rules because the oceans cover more than 2/3 of our planet. So that is the significance of UNCLOS. Now, as with any written rule, what happens if people disagree or people fight over the oceans? To make it very simply, UNCLOS has a compulsory arbitration provision, meaning if you join UNCLOS, you must bind yourself to be bound by arbitration. If you have a party there, you have a dispute with all of you who sign UNCLOS are bound for compulsory arbitration. There are some exceptions, which we will go to later. So, very important also with UNCLOS. Remember, it is a convention, it is a constitution, it is a law for the sea. Only for the sea and only for the sea. Okay. Meaning, it is not a constitution for land. It's only for the sea. Okay? So, the word sovereignty. Kanina, remember your word sovereignty? Sovereignty, well, to the first year law students, to make it very simple, is akin to but is not. You own. If you are sovereign, you own in simplistic terms. So, the Philippines has sovereignty over Philippine territory, as in you own. But the technical term is you have sovereignty. Okay? Now, so UNCLOS is not about sovereignty over land. It governs, as I said, waters or seas. It is not also sovereignty over territory. It only governs use of the oceans. Okay? But there is a paradox about UNCLOS. While it talks only about rights to the sea and to the ocean, you cannot divorce a certain connection to land. Okay? Why? Because there is only land and there is ocean. Okay? So ano ang connection between land and ocean, between land and water? Can you have the next slide, please? Before UNCLOS, you have this legal maxim which will take up either in Consti 1 or public international law. That meaning the land dominates the sea. The land dominates the sea. That's not found in any of the articles of UNCLOS. What it means is that you cannot have rights to the sea unless you have land. In very simple terms. So, your rights to the sea, ibig sabihin, if you have land, you have Luzon, or the edges of Luzon, you will have under the Republic Act, which you will study, you will have the sea. So, all measurements come from land. That's the paradox of UNCLOS. While it talks of sea, land dominates the sea. Okay. So, again, UNCLOS is not about land ownership or sovereignty, but what is called rights to the sea. And what are the rights to the sea? Do you see the edge is land? Assume that's Luzon. From the edge, you measure the baseline. The baseline is governed by a Republic Act. You will study that. from the baseline, which is loosely the edge where the water starts, you measure 12 miles. That is called the territorial sea. Now, tingnan nyo at the bottom. What does it say? Sovereignty. That means in the territorial sea, which is 12 nautical miles from the baseline, the Philippines, which Luzon is part, has full sovereignty. Okay? Now, again, from the baseline, you measure 200 nautical miles. Do you see that? Then you see, from the territorial sea, you have an exclusive economic zone of 200. Okay. Now, at the bottom, you see, because sa baba ng water is some seabed called the continental shelf. And at the bottom, you have the term sovereign rights. That's a term of art. You don't call it sovereignty anymore, you call it sovereign rights. So, in very simple terms, the rights you have to the sea are essentially territorial sea, an exclusive economic zone, territorial sea, full sovereignty. Exclusive economic zone, you have sovereign rights. You don't have sovereignty, but sovereign rights means the right to exploit natural resources, fish, and including to drill at the continental shelf. Now, beyond that, there's an outer shelf. You can have sovereign rights if you apply for, depending on the slope, it's a very technical matter. You can have an extended continental shelf, as has the Philippines done in the eastern part, in the Pacific. So, beyond that, that's what they call the area. That's for mankind. That's for mankind to exploit. So, do you see now, they understand the principles. Under UNCLOS lays down rules on how do you measure entitlements to the ocean. But again, the catch is, provided you have land. Provided you have land. Now, go back and take a mental picture again of one of our first slides. What do you do now with the many features in the South China Sea? Remember, there are 750 reefs. What if somebody puts an installation on top of a reef? Is that now called land? That's what China did to Mystic Reef. Do you measure now a 200 economic zone from that reef? Remember, that is a reef. Okay. So that's the issue. That's why at the start we use the word feature. Now, so how did UNCLOS translate land dominates the sea? The next slide is the rules is under 121 called regime of islands. So how do you determine whether the feature will have rights? It will depend on whether it is an island, it is a rock, or it is a so-called low tide elevation. Do you see that? So, ang paglalabanan is whether a feature, to repeat, is an island, is a rock, or a low tide elevation. Now, island, naturally formed area of land surrounded by water, above water at high tide. Best example, Luzon. Luzon is naturally formed, it was not reclaimed. It is surrounded by water to the east and to the west. It is above water at high tide. Sometimes parts are flooded, but it's above water at high tide. Now, under UNCLOS, to what is Luzon entitled to? The full panoply of rights, the whole kabudon. 12 nautical miles territorial sea, 200 nautical miles EEZ or continental shelf. But Luzon is not contested, so that's easy. I don't think Les will ask you that question in your quiz. Now, the next category is rock. Rock, as in bato. These are reefs mainly below water. But they have rocky promontories that protrude at high tide. So they are mainly below water, but have rocky promontories that protrude or moose boom during high tide. Now, the key words, the sacramental words are, they are considered rocks because they cannot sustain human habitation or economic life on its own. Best example, and we already took this in our submission, Scarborough Shore, Panatag. It's actually a reef under, but there are 5 rocks, now moose boom, that are always above high tide. But they are like one square meter each, or 2 square meters. So, obvious ba na it cannot sustain human habitation or economic life on its own. Example, mag-date kayo ng boyfriend mo o ng girlfriend mo. Magpahatid kayo sa one of the promontories. Iiwanan kayo doon. Diba? Kasi akala nyo, mayroong forever. You will be given 1 week supply of water. Okay. What do you think will happen after 1 week? Maybe it rains, maybe it doesn't rain. If it doesn't rain, if you are left in that rock, it cannot sustain human habitation, literally. Okay. So, what happens if it is just a rock? As against Luzon. Luzon is an island. No, it has only 12 nautical miles of territorial sea, but it has no EEC, no 200. And that's very important. That is the difference between Panatag and Luzon. Okay? Now, the third category is low tide elevation. Ito yung reefs. Remember I said there are more than 750 reefs in the Spratly. The best example is Mischief, where China put up an installation. It is not visible above water at high tide. These are submerged reefs or artificial islands. The best examples would be Mischief Reef and our own Ayungin Shoal. You're familiar with Ayungin Shoal? This is the one off Palawan where we grounded an old landing craft. That's a reef. The landing craft is visible, but no part of the reef is visible above during high tide. Now, if it is a reef or a submerged reef or a submerged island, what is its rights under UNCLOS? Nothing. No territorial sea, no EEC, no continental share. So, in a nutshell, in Regime of Islands 101, that is what 101 means. That's why we thought that we can bring the matter to arbitration based on the theory. Again, what's the theory of the case? UNCLOS applies. If you apply the terms of UNCLOS to the facts, to the fact that Panatag is like this, that Ito Aba is like this, that Kalayaan is like this, then you will arrive at a certain result. If a feature is called an island, then alam nyo na to what it will be entitled to. If it is merely a rock, it has less rights. If it is submerged, it has no rights. So that is what is called the theory of the case. In your first bit, you will be applying the case, the facts to the case. That will be the result you want to get from the tribunal. Okay, so what were the submissions? What were the things that we submitted to the tribunal? You have it in the next slide. So essentially, the first claim was China has absolutely no claim to the 9 dust lines based on what it claimed as historic rights, because there are no historic rights under UNCLOS. Remember, as I said, UNCLOS is based on measurements from land. it is not based on history. UNCLOS, when it was adopted in 1982, said whatever is the prior history, previous history, now we say rights to the sea depend on measurements from land. So that is why, in very simple terms, the 9th land of China has no legal basis. Now, number 2, we wanted to have a determination in 9 features that we brought to arbitration on whether they are rocks, islands, or submerged lands. And then we brought to task China for its actions in Scarborough Shoal, preventing fishermen from fishing, and the construction of the reclamation constructions in mischief reef, violation of our rights. So now you understand how to prepare a case. You have facts, and then you research what is the law, and then if you apply the law to the facts, do you think you will get a favorable decision? That's what yes, a case is all about. Okay. Now, when the Philippine team, including, can we have the next slide? What happens next in practice? You are the lawyer. You made already. This is the theory of the case. What happens next? You go back to your client. Okay. Who is your client? The client is the President of the Republic of the Philippines. And why is he the client? Because the President of the Republic of the Philippines is the singular executive and the heads of foreign affairs. So this was a purely executive action. Whether to file or not, rested on the shoulders of President Aquino. And that is why they say it's lonely at the top, because it's a very difficult decision you make on your own. You may have all the advisors, you can have foreign advisors, you can have a consultative group, but the way they will distill it is they will push up the decision to be president as it was done. So just very quickly, towards, we worked a lot, and towards December of 2011, the team had a proposed complaint or submission, as it is called. By January 7 of 2013, we were told already, get into almost ready position to file. We made a last trip to DC, January 11, did additional work. By January 17, the memo of the executive secretary was ready for the president. And there were meetings before that, and the president with us, and I was asked, what about jurisdiction? Is it true that they can throw out the case? Give me a percentage. Can we win? Give me a percentage. I had a very difficult time. He said, sir, a trial lawyer will never give you a percentage. We have arguments. Jurisdiction is a problem. In fact, Griezmann of Yale said we had less than an even chance of surviving jurisdiction. Why? Because you are going up against a major power. Why should they entertain a suit from the Philippines? There were enough technical arguments to oust us of jurisdiction. For example, China has an opt-out clause, meaning if it involves a boundary delimitation, the tribunal will not have jurisdiction. Of course, we argued that the opt-out clause was not applicable because this was interpreting application of UNCLOS, not boundary delimitation. But again, the argument was, kung gustong i-throw out, maghahanap yan, it can be thrown out. Nobody should dare mess with China. Okay, but why would we allow ourselves to be used with the Philippines to mess with China? On the other hand, the writer, the law firm, this is a golden opportunity. This has never been passed before. If you allow us, we will argue. And we are sure the tribunal will not pass up the opportunity to rule on the case. So, you have one argument on the one hand, but of course, you take it with a grain of salt because Because the lawyers will be paid in the process. If you win, they will win with you. If they lose, you will lose alone. So I refuse to give the president a percentage. And I think he was not pleased, because he's a layman. Laymen think that lawyers can give them a percentage of winning. And this is the problem of necessary third party. Those who are seniors, this is the indispensable third parties. Meaning, Vietnam has some claims. If Vietnam does not become a claimant, then it can also be thrown out. Enforcement. After we won, then many people criticize, but you cannot enforce it, because the reality of international law is there is no such thing as an international policeman. There is no policeman who will enforce it. Now, we knew this from the start. So again, the question was, well, if we cannot enforce it, why fight? In fact, the president said, if we lose, what will happen? So I said, sorry, you will have expense, but more important, reputational damage. We will be damaged in the eyes of the world. We put up a case in a papahiya tayo. And the president had to grapple with policy issues. Should you file or just continue bilateral talks? Because China can do many things. They can escalate trade war. They can reject our bananas. They can send home. And that was a real problem. They can send home our UFWs. That is why we have this slide, because after the victory, we should not forget the one who made the decision was the president. And in fact, I can tell you, when the decision was out, Florin Hilbay and Justice Bentadiwa, who is an Athenian, we were all in my chambers waiting for the decision, because we had a pact. As JFK, my favorite American president, famously says, victory will have 1,000 fathers, but defeat is an orphan. So of course, we hope, we pray that we will win. By the way, Justice Kadiwa was Chief Presidential Legal Counsel, helped us in the case. But what if we lose? Fortunately, we won. And that is why, when we won, ingit nga kami, tinawagan niya Percy, not the justices. But when Florin gave us the phone, what I asked the president was, sir, please do your memoir sooner rather than later, because I would really like to know how you decided. Because I saw in one of his exit TV interviews, he said this was the most difficult decision of his presidency. So remember, January 17, we had a final memo to the president. We filed January 23. So the president must have made a decision somewhere there. We filed January 23, 2013. The day before, we got instructions to finalize everything, because the next morning there was a full cabinet meeting. It was approved, National Security Council meeting, both parties in Congress, and unfortunately for me, that was the night before the oral arguments in the Supreme Court on cybercrime. There was a challenge to the cybercrime law. So I was not able to sleep because I was doing my arguments to the court. But I had to be in Malacanang before 6 because we had to finish the slides for the presentation. And mabuti na lang, when we filed, sabi ko kay Presidente, ako na po magdala sa Supreme Court to inform them, panay, sabay, sa Chief Justice, ma'am, pwede ba ipa-reset na lang muna the cybercrime. So, we filed. Now, the next slide on the arbitration proceedings. This is what happened. The tribunal was constituted. Florin will have more than. We submitted the memorial on March 30, 2012. The memorial is the written submission. There were 2 hearings in jurisdiction. I stepped down as agent March 15, 2015. All of these, the hearings already happened during the term of fluorine. Now, I'll go straight so that we can segue now to fluorine. Very, very quickly, what is the tribunal's award? Remember our claims? What was the dispute all about? And what was the big win that we got? Number one, on the claim of China that it has historic rights to 9-9. The tribunal said very, very clearly, contrary to the convention and without lawful effect. To the extent, ibig sabihin, absolutely no legal basis, no historic rights. The rights of China will be measured according to its entitlements, according to UNCLOS. Okay. Now, remember, the southernmost part of China is Hainan. It's more than 600 kilometers from Scarborough Shoal. So, you cannot claim historic rights and go 600 miles to the south. So, that's the ruling on historic